In hindsight, I should have predicted that that could have been a problem. I was like, "I'll just unplug it." Did not expect unplugging the camera to break the stream altogether, but shows what I know. Let me just make sure this link gets out so that people can find me. That's not someone knocking on my door. Thank God. Boop, boop. Alright, put it in the YouTube. Put it in the Twitter. Da, da. Pin. Thank you guys for bearing with me. Like I said, this is the first time I have done this, and I don't know what I'm doing. And on my third platform, here we go. All right. Sorry about that. Should have predicted that maybe just yanking the cord would be a bad idea. Like I said, brain's a little fried. Did not expect unplugging my webcam would fully freeze the whole live stream, but that's apparently how it goes. But I'm not blurry anymore, so there's that. Da, da, da. Someone just sent me a picture of my face when I unplugged the webcam, and that's amazing. That is so funny. Oh, no. Okay, are people here with why does it say I don't have access to this feature? What does that even mean? Okay, there we go. For some reason, it wasn't showing me the chat, but you're back now. Sorry about that. Okay, so I was talking about North Dimension. I can see the chat now. Something was wrong with it, but I fixed it. Enjoy that picture of my face. Feel free to make memes of that's my reaction. Honestly, that sort of is my reaction to a lot of what happened today. So, yeah, that's gonna be maybe I'll make that into my own reaction image. North Dimension. So there's this whole thing about FTX and bank accounts where FTX could not get banking because the whole banking industry does not particularly enjoy giving service to crypto companies, especially back in the day when, I mean, this was not that long ago, but when FTX was first created. And so they had this whole setup where people would actually wire funds into Alameda, and then Alameda would sort of credit your account on FTX, even though the money was actually in a bank account belonging to Alameda. Now, at some point, they decided that they were going to set up this other entity that was called North Dimension. And I'm pretty sure this did not come up in testimony today. I'm pretty sure they had like a fake website where it looked like it was like an electronics retailer or something like that. But like, it seems like they probably created this and named it in such a way that like they were trying to not make banks catch on to the fact that they were doing crypto stuff. Which is, again, the whole reason that Alameda Research was called Alameda Research is that, like, they didn't wanna have anything crypto related in the name. Um, but there's this whole bank fraud charge, and there are all these questions around, like, what the hell was going on with that banking, relationship, and they really focused in on this North Dimension thing. And so they bring up this document, or they ask him about basically the sequence of events that led to North Dimension getting set up after. So they basically the money was coming in through Alameda Research, and then for a period of time. It was coming in through this North Dimension bank account. And they ask him about the sequence of events that led to them setting up this entity, because it really seems like it was just trying to evade banking checks. And so he basically says, like, I had a lot of things that were coming across my desk. I trusted Dan Friedberg. Dan Friedberg was the one who wanted to set this up, or like he was the one sort of filling out all this paperwork. And so when he got this document, like, yeah, that's my signature, but like I wasn't really reading it that closely. I signed it. Um, they Yeah, so they have the application, the application for this bank account. Um, it was backdated? No, sorry, they didn't show that. They have an application now that they were showing that was, an agreement between FTX and Alameda Research saying that, like, "It's totally cool. We are processing, FTX customer deposits through Alameda Research, and we have this payment, agreement that sort of records that." The awkward thing about this agreement is that Sam Bankman-Fried signed it. The effective date was, like, way before. So this was, like, backdated. And Sam Bankman-Fried, the defense is the one asking him this because I think they know that the prosecution is trying to say that, like, they made this false document, they backdated it to make it look really shady, or to make it, and it was really shady that they did it, but they were trying to make it look legit in hindsight and all this stuff. And so they were trying to sort of get out in front of that. But critically, one of the things that Sam said at this point was that he said something as though this was totally normal, that FTX had attempted to get FBO accounts, which is, for the benefit of others, I think is what the acronym stands for, but it's basically like bank accounts where you're holding customer funds. He said they had been basically trying to get these bank accounts since the inception of FTX, and quote, "It took a couple of years to get these bank accounts." And that was all he said. Like, no explanation of why that might be, like, what was happening during that period of time that they were getting, like, repeatedly declined. He's like, "It just took a couple of years," which I thought was really funny. He was just, like, totally trying to skirt around it. But he fully believed that, FTX and Alameda, the sort of relationship, the banking relationship there was permissible. And they had, the defense trotted out this bank account application that was filled out by Dan Friedberg and this, like, diligence form. Um, and so that was that whole thing. We'll come back to it about in the cross-examination. Um, there was then some talk about the way that Alameda Research was doing these venture investments, and the fact that the funds were coming from Alameda Research, but there were various entities that were doing the investing because, again, in some cases, he was saying that, like, well, the companies we were investing in didn't want Alameda Research to be the one, using that wasn't the name they wanted connected with this investment, which again is like, so you were concealing the source of the funds? Like, that doesn't seem really above board, but, like, that was kind of his, argument there, and he was saying that, like, "Oh, yeah, sure, we were doing all these loans through executives, and, maybe that looked shady now, but, like, there was, this heavy overlap in the ownership, and so what does it really matter that it was my name on the loan versus some other entity that I'm, like, the primary owner of? It's all the same money, whatever." Um, there was a funny point where the judge actually interrupted Mark Cohen, who is the lead defense attorney. He had asked some question that was like, "What was your understanding about blah, 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 blah?" And the judge interrupts and goes, "The better question would be, what did you say to them and what did they say to you?" Because he was, like, getting annoyed at this really vague questioning, and then also these really weird answers that Sam Bankman-Fried was giving that were, like, super evasive around, like, "Well, if I recall my understanding at the time, like, blah, 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 blah." And so I think the judge was frustrated both at the questions and at the responses, but there was this sort of laugh moment in the overflow room, and someone made some joke about, like, "Is this law school?" Um, And at one point, Cohen asked, "Did you take comfort from the fact that the lawyers had structured the loan?" And that's they keep coming back to that, like, he took comfort in that, which must be some sort of a legal thing because it seems like really weird, wording to me. But I think that's, like, what they're trying to argue, like, "Oh, no, this isn't a formal advice of counsel defense. This is just us showing that he took comfort that lawyers were, signing off on this stuff." So, that was kinda weird, but then they move on to the terms of service, which earlier in the trial, Can's son had testified about. He was the lawyer who had he basically like he hasn't been charged with anything. I think he was testifying with immunity, but he basically discovered at some point that there was this fund transfer happening between Alameda and FTX, and he was like, "Oh shit, that seems really bad." But he felt like it was being addressed, and so he stuck around. And then when everything totally fell apart, he like quit the next day and went to the feds. So he's not super implicated in any of this wrongdoing, but he did testify earlier on about the terms of service that FTX customers were agreeing to. And that they were highlighting in particular that it addressed margin trading and it told customers that that FTX could lend out their funds if they were using this margin feature, which I think is going to, again, be kind of a key point of this defense where, like, they technically said it was okay and blah, blah, blah. The judge asked Sam Bankman-Fried if he read the entire document. Sam Bankman-Fried said he read parts of it in depth and parts of it he skimmed, which I thought was funny. Who reads terms of service, I guess, even when you're the CEO of the company? One other thing they highlighted was the possibility of clawbacks. So there's this part of the FTX terms of service that says, as a customer, there is this possibility of like these socialized losses, and that if something really goes to shit, your money could be clawed back, which again, I think is going to be a part of the defense case. He was asked if he believed that Alameda Research's borrowing from FTX was permitted, and he gave this really roundabout response where he basically said, in many circumstances, I think it was okay. This was, again, the defense that was questioning him, so they didn't go super hard on that. At one point, so they've just gone through all these questions with the terms of service, and then at one point, the judge or the defense asks him something along the lines of like, I get this in interviews a lot where you'll do this whole interview, and then at the end of the interview, the journalist will be like, "Is there anything that I missed that you want to add?" And it's like kind of a nice thing to do in like a media interview. Pretty weird thing to do in a trial. He basically was like, "Is there anything else relevant about this terms of service that you want to chat about?" I forget how he worded the question, but everyone was like, "What the fuck?" And there was like this sort of weird moment of like confusion, and then I forget if there was an objection or if he just rephrased the question, but they asked if there were any other conversations that he'd had with Can's son about this terms of service. And then there were some questions around, did FTX have other versions of this terms of service? And yes, there had been several versions of it over the years, plus like minor edits and stuff. So yeah, I'm not sure where they were going with that, but that was brought up. They asked, and so then they switched topics again, and they asked him, "Did you intend to safeguard assets?" Yes, like that was supposed to be the response. They talked a little bit about segregation of assets, primarily in respect of separating corporate assets from the Omnibus customer wallet. He kept talking about physical Bitcoin. He was like, we were putting in place these physical safeguards, and we were, oh, well, if you have these, if you didn't have omnibus wallets, then you'd have to have individual wallets for every customer to put their physical Bitcoin in. And I was like, what the fuck is a physical Bitcoin? Like, I'm just picturing this like weird novelty coins that they make that have like the Bitcoin logo on them. Anyway, I just thought that was funny. They asked him some questions around, to your knowledge and from your conversations with other crypto executives, like, did you believe it was normal to have these omnibus customer accounts. There was a point later on at the end when they were going over objections and stuff where the prosecution was like, we don't really have any issue with this whole omnibus customer account thing. Like, we acknowledge that that's how they were doing it. We're not trying to prove there was any wrongdoing about the fact that customer funds were pooled in these omnibus accounts. Like, so I think they've kind of handled that and probably won't go into it. But during this portion, he did this long response about how it's totally normal for for centralized exchanges to have these omnibus accounts because that's what keeps you from having to pay, like a Bitcoin gas fee or an Ethereum a Bitcoin transaction fee or a Ethereum gas fee anytime you move money around in your, through a centralized exchange. And he goes into this whole like tangent about decentralized exchanges and dexes and like what that means and why centralized exchanges you have to have, the customers all have to pay gas fees and so people don't really use them that much. And like it was this total divergent. He started talking about Sushi Swap and Uniswap. And like, again, the jury was not there. If they had been there, it would have just been like, what the fuck is he doing? Like it was just so much of a tangent and so unrelated. And at this point, the judge asks Sam Bankman-Fried to explain to him what a blockchain explorer is. And so for those of you who might be familiar, Etherscan is a good example. It's one of those websites where you can just look up like a Bitcoin wallet address, an Ethereum wallet address, something like that. You can see the transactions. Look, I just answered the question. Super easy. You can just go online and see, you can look at what's going on the blockchain. Sam Bankman-Fried starts talking about what a blockchain is, how they do all this distributed compute. Validators come up at one point. He starts talking about how it's not reasonable for most people who are just curious what's going on the blockchain to run a node so that they can understand, just so they can just look up a transaction. And so he finally gets to this answer about what a blockchain explorer was. It was like, buddy, what are you doing? Like, you don't need to explain what a blockchain is. Just explain. It's just a website where you go and you can see what's happening on the blockchain. That's it. Like, it's so easy. Anyway, doubt that will actually come up in like the real version of this because, again, I think they've sort of agreed on they don't have to go into this whole omnibus wallet thing, which is how the blockchain explorer thing came up. But it was just like, dude, read the room, They talked a little bit about the meeting with the Bahamian Securities Commission and did not really talk about anything of substance at that point. All right, 2:15, cross-examination. So what time did the defense start? It was after lunch. I don't have it written down. 2:15 doesn't seem right. Anyway, whatever. We get to the cross-examination. They go back to the beginning. They start talking about Signal. The questioning was basically like, did they discuss all of the Signal auto deletion stuff with their lawyers? Super evasive on this. He was like, I don't really remember. He's like, I think maybe the lawyers were in some of these chats, so maybe they would have realized it, but like I wasn't talking to them about it. I wasn't really getting their advice on it. He discussed that it existed, that this auto deletion feature was being used, but like wasn't really asking them if that was legally okay and all that stuff. He was giving these long, like halting answers, long pauses, just coming off to me. I thought, I mean, I have a bias obviously, but I did not think he was coming off as credible. For those of you who've read some of my past newsletters or who have been following the trial, at one point in an earlier portion of the case during Can's son's testimony, they played a clip where he had done an interview with George Stephanopoulos on Good Morning America. And he gets asked a question and then George like pushes back a little bit. And then Sam Bankman-Fried is like clearly off guard and he like pauses and then halts and is giving this really weird answer. And it just seems really cagey. That was exactly the same demeanor that he was doing at this point. And this was again, like first question about the prosecution. And I was like, oh fuck, like this is not gonna go well. And like, I'm not rooting for Sam here. Like he's guilty. He's gonna do jail time. justice should be served here. But it's hard not to feel like, come on, at least put up a good show, like try to be credible. Um, it was like kind of watching like watching a car crash, it's just like, oh God, this is so hard to watch. I mean, I enjoyed watching it, but it was hard to watch. Talks about changing his Signal chat to do the auto deletion. Again, does not seem to have sought approval from his lawyers. Talking about the fact that the written document was established on document retention was established after that, but again, didn't really talk about Signal. Um, at one point, Sam Bankman-Fried does, he has this sort of demeanor when he's answering questions where he'll use big words and try to like go answer some other question or talk around it or give this really meandering response. And at one point he said something about like, I believe there was permissibility around something, 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 around having Signal chats auto delete. And Judge Kaplan is like, what does it mean that there was permissibility? And he goes, does it mean you can do whatever you want? And like, we start to see very early on Judge Kaplan getting annoyed with Sam Bankman-Fried's way of responding to questions. And even with the defense, like I was surprised, they've known he's going to testify, I think probably for a little while now. They've had access to him. They've been able to coach him. you know, I feel like anyone who's seen a movie with a trial is like, you just answer the question you're being asked. You don't offer more information. You don't answer the question that you think they're asking you. If it's a yes or no question, you say yes or no. You don't elaborate. Like, I don't know if this is common knowledge, but like, it's not super unusual. Does not appear to have either learned any of this, or I suspect more likely does not appear to have absorbed what he has been told about this, because he was giving long explanations. He was saying, what I think you're asking is da 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 da. Not great. Oh my God. So they're talking about this document retention policy. And at one point, the assistant U.S. attorney, Danielle Sassoon, says, where is that document? This policy that he's been making repeated reference to. Sam Bankman-Fried says, I'm not sure if that's admissible. And the judge goes, don't worry about admissibility. You worry about blockchain explorers. Like, Sam Bankman-Fried is sort of trying to be like his own lawyer over here. Like, I don't know if this is admissible. Like, just answer the question. The jury's not even there. It doesn't matter if they object to it. No one's gonna get, they're not gonna have to strike anything from the record. Just answer the fucking question is basically what Judge Kaplan was saying. And so he obviously answers the question at this point. And basically what was coming out was that the defense team has requested some documents from, I believe, from Fenwick and West, which is the legal firm. And I guess it was kind of a broad request. And from what I could understand from the conversations today, it seems like the FTX bankruptcy team has actually objected to some of those documents being released. And so I'm going to skip ahead a little bit, and then I'll come back to what we were just talking about. But no, my spit shield. I need this. They were saying, so they had served this subpoena on Fenwick and West. The debtors objected, and the subpoena was denied. The judge asked, did you serve a trial subpoena? And they said no. And so basically, like, they could have asked much more forcefully for this document. It doesn't seem like the prosecutors basically said, like, they asked for it once and then they gave up. And so, but now they're trying to say, like, oh God, we don't have the, this document that we really need. Oh, isn't that unfortunate that they wouldn't give it to us? And so towards the end of the conversation, they sort of talked about, like, to what extent is Sam Bankman-Fried allowed to say that versus, is he allowed to say that? And then if he does say that, can the prosecution basically say, well, you didn't really try that hard? And it sounds like they're perhaps going to be allowed to make that point if Sam Bankman-Fried tries to say that, like, oh, we tried to get this document, and then we couldn't. So I suspect, I mean, I'm no lawyer, but I suspect his legal team is going to say, do not go there. We don't want to have this brought up because it's going to weaken our case. Yeah, so this at this point, Sam Bankman-Fried has said the words formal business decisions about 400 times. Um, all of what he's been talking about with this document retention policy is which documents need to be retained, and some of them are any documents pertaining to a formal business decision. And it immediately became very clear that he was operating with a different definition of that term than the prosecution. Um, he so I'm not, again, I've said this a million times, I'm not a lawyer, obviously, I don't know anything about document retention policies, I'm not a CEO. He seemed to believe that the the formal business documents were anything that was, like, policy that had been decided and then needed to be disseminated to the rest of the company. So, like, if they come up with, again, let's use the document retention policy. They've decided on this policy, it's final. They send it out to the company. The employees are supposed to enact this policy. Those have to be retained. From what he was saying is like anything besides that is like no holds barred, just trash that, like doesn't matter. And I was getting the impression that the prosecution did not agree with that definition. Um, and this is the first time I saw Danielle Sassoon really sort of working up to corner him. I suspect there will be more of this, but she starts to ask him, how do you distinguish a formal business decision from some other document or conversation or chat or whatever it is? And so he gives some sort of answer to that. He says, well, I don't think any sort of rough draft is a formal business decision. I don't think like discussions of these policies that hadn't been formalized yet would qualify. She says something about, what about the decision to repay Alameda's lenders, which was something that we've already seen in evidence that was discussed on Signal, where they, as the company was collapsing, Caroline Ellison was like, should we start repaying, all these lenders are trying to call back their loans. Should we repay them? And this was just happening on the Signal chat, which was set to auto delete. And so he says, well, no, like it wasn't a policy, or I forget exactly what he says, but like he's like, oh no, absolutely not. And then he says something like, it wasn't a formal business document. That was just like a conversation, or, it was just like, we were just chatting or something like that. And so the AUSA immediately comes back and says, okay, what about balance sheets? Is a balance sheet a formal business document? That seems really formal. It's a spreadsheet, it shows the company's financial condition. And he has to be like, oh crap, like, no, it was a rough draft and those weren't the final documents or whatever. But like, it was pretty clear at that point that she had sort of gotten him into an awkward position. And then she starts asking him like, okay, what about your chat with Caroline Ellison? Like, wasn't that had auto delete on it? But those seem like there were a lot of business decisions being made in that conversation. And he was like, well, those are, mostly just one-on-one conversations. Like, it didn't seem like that was critical. Clearly, those weren't formal business discussions. And she was like, you were the CEO of FTX. She was the CEO of Alameda. How was nothing you said in that conversation of like a formal business decision? And she basically got him to say, she was like, is your testimony that nothing you two discussed in that Signal chat was a formal business decision? And he tried to couch it, he was like, well, to my recollection, I don't think there was anything, that kind of thing. But like, that's the type of thing that I'm like, does she have some document somewhere where she's going to whip it out and it's like clearly a very formal decision? So that was that. They started to talk about, let me just quickly check on the chat. Oh, the theory now is that the camera is focusing on my mic. If I move that out of frame, will it be better? And also, can you still hear me? Just let me know. Doop-a-doo. Da-ba-da. Sarah Palin objected to a question. That's awesome. I could see Sam Bankman-Fried doing that. Someone asked if it was decisions or documents. They referred to both. Not sure what law they're drawing from, but they used both terminology. It was decisions and also documents. Sound is fine, quieter but peaky, less peaky, hopefully in a good way. All right, awesome. We'll keep going. So, we get into signal messages and the quote that he had said. I think it was Adam Yedidia maybe who testified to this early on. He was one of the first witnesses, and he said something along the lines of like, Sam Bankman-Fried told us that we should auto-delete our signal chats because retaining them is, quote, all downside. And I think he was at that point specifically talking about regulators. And that was like a pretty damning thing to say. And so they asked him basically, like, do you recall that testimony? And he said, yes, obviously, he was there. And then, did you have that conversation? And he, again, is like, you know, I don't know if I really recall. I may have had discussions to that effect. At one point, yeah, he started to say basically that, like, well, what I was really concerned about was that if someone got hold of these signal messages, well, our employees' statements could have been made, you know, in an unguarded way and without context. And so if they were published or leaked or whatever, it could be damaging to FTX's reputation. And he once again brought up what Caroline Ellison had testified about earlier in the trial, which was this New York Times test, which is something he picked up from Jane Street. And it was basically, you know, when you're writing something down, ask yourself, would it be embarrassing or damaging to the company to see this printed on the front page of the New York Times? Now, I made this comment then, and I'm making it again now because I feel like it's not the best idea. I don't know if the jury is going to know about this, but I feel like maybe when you have been sent back to jail for publishing your girlfriend's diary entries in the New York Times, maybe you shouldn't be talking about the New York Times test, my man. Like, dude. Anyway, so he talks about that. And is trying to say, oh, it wasn't regulators I was worried about. It was, I guess, the press. I don't know, something. All very awkward. And then he starts getting asked, did FTX ever receive data retention subpoenas? And he said, oh, yeah, sure. You know, like totally. Well, did you ever preserve signal messages in response to those subpoenas? And he was like, oh, well, I talked to my lawyers, you know, Ryan Miller and Dan Friedberg about this. You know, did you ever basically make any changes to these document or to these retention settings in Signal? And it sounded like basically no. So that seemed pretty weird. They go back to questions around what is and is not a formal business decision, which was kind of exhausting. Did any lawyers ever tell you that spreadsheets qualified as informal business decisions? And he said, well, no. At one point, they asked him specifically about a chat that was called Vertex. Okay, I'm blurry again and my mic is not in the frame, so I think maybe that's not it, but I'm going to still leave it over there because apparently this sounds good. There was a chat called Vertex where it was like him, Caroline Ellison, Ben G, I think is how you say it. I'm not sure. And maybe one or two other people, Sam Trabucco maybe, where they were basically discussing like what trades Alameda Research should make. And the prosecution was, I think, trying to make the point that like, that sounds like a business decision. But during this point, I think he sort of tried to squeak around something that's likely to come up, which is the extent to which he was involved with decisions at Alameda. So for those who don't follow this case as closely as I do, which is, I assume, all of you, he was the CEO of Alameda. Obviously, he founded it. He was the CEO for a long time. And then at some point, he transferred CEO-ship to two people. They were co-CEOs, Caroline Ellison, Sam Trabucco. Shortly after Sam Trabucco became CEO, he had been this like hotshot trader. He was like the best trader there. He was just incredible at his job, I guess. Well, he was named co-CEO, and I guess according to both Caroline Ellison and Sam Bankman-Fried, he like immediately checked out. He was like done and started like just not showing up to work. He wasn't doing stuff. So he was out in like August of 2022. But there's this whole question around like to what extent did Sam Bankman-Fried actually like step away from Alameda Research and hand it over to Caroline Ellison, and like his defense was trying to make some arguments that like he was not in charge there and it was all her fault and Sam didn't even know what was going on. And so I could see him sort of trying to skirt around this and say that like, well, I was involved with Alameda's venture decisions and later in their hedging. He was like, I wasn't involved in their trades, but I was involved in their hedging. Because his whole part of this whole defense is like he was trying to tell Caroline Ellison to do some of this hedging that she never did, and it wasn't all her fault because she didn't make these hedges that he wanted her to put in place. So I thought that was really funny, where it was like, I don't know if anyone's going to believe you on that. And of course, they ask him, do you have any paper records with these attorneys? All these conversations that you claim you were having with these attorneys where they were like, yeah, go ahead, delete whatever you want. No, he doesn't have any. This was kind of a spicy moment. He just said, no, he doesn't have any of these documents that he's been talking about. He doesn't have any communications with the attorney. He doesn't have this document retention policy. He doesn't have earlier they had said they didn't have access to the terms of service. They eventually found them. So I think they just meant they couldn't find them in their records like at that particular moment, but they do have them and they were entered into evidence. They did not have this document retention policy, which Sam Bankman-Fried had earlier said they had tried to subpoena and couldn't get access to. Well, guess who does have it? The prosecution. They have like a paper copy and they go up to Sam Bankman-Fried with it and they hand it to him and they give one to the judge. And they ask him, do you recognize this? Does this look familiar to you? At this point, he's holding a piece of paper, which is like, he's sitting at this wooden bench, booth kind of, and then there's like a little TV screen or computer monitor in front of him where you can see exhibits, and then you can just see the top of this piece of paper that he's holding up, and it's like, he's holding it and it's like you can see it shaking on this little monitor. It was like, oh geez, bud, put that down because everyone can see that you're shaking. Anyway, he says the document that they handed him was not the document retention policy. And I don't know what happened there. I don't know if he was lying. I don't know if he was saying it was an older version. He basically was like, this isn't it. And then I was looking down, taking my notes, but the lovely lady sitting next to me said she basically leaned over and he's like, she just put it down like it had burned him. Like he was like, so I don't think that was on the plan. We'll see how that comes out tomorrow. So that's kind of the weird thing about them doing all of this without the jury present is like, presumably they do this all over again tomorrow, which like, that seems kind of weird. And obviously that gives them like a practice run, but we'll see how that goes tomorrow. All right. North Dimension cross-examination. They first start out asking him about the name. He says, I honestly don't know where the name came from. Did you come up with the name? He says, no. Doesn't know why. They're like, do you know why it doesn't even mention Alameda Research? Because it was a subsidiary of Alameda Research. And he's like, nope, don't know. Like, all right, sure. At this point, I take a note that he's offering to answer questions that he thinks the prosecutor is asking him, which again, as far as I've heard, I've never been unfortunate enough to have to testify in my own defense. So from what I've heard, most defense lawyers advise against that. They point out that, well, first of all, he says that banks had difficulty transferring funds to Alameda Research because of the crypto association. And I was like, banks had difficulty. Like, that's a weird way to say that banks want nothing to do with your ass, and it's like, "Oh, yeah, it just didn't go through." Like, it's just such a like, come on, my man. Um, and then so they're saying he's like, "I don't know anything about North Dimension. I didn't instruct that it should be created." And the prosecutor comes out and says, "You were CEO of Alameda Research when North Dimension was created. Like, you didn't know anything about it or why it was being created." She goes, "Is it your testimony that you didn't know why Alameda Research started receiving deposits, or sorry, North Dimension started receiving deposits instead of Alameda Research?" Like, and he gives this long answer that he was basically like, "Well, I kind of noticed that the deposits were going into North Dimension instead of Alameda Research while I was the CEO of Alameda Research." And it was like, all right, okay, if you say so. At this point, I write down, where the fuck is Dan Friedberg? Because he's coming up over and over and over again as Sam Bankman-Fried's like get out of jail free card, where it's like, oh yeah, Dan Friedberg said I could do that. Dan Friedberg made that document. Dan Friedberg put together North Dimension. He testified that he wasn't sure who made the original decision that North Dimension should be used to receive FTX customer funds. Again, weird when you're the CEO of both FTX and Alameda. At that point, he starts to sort of walk it back a little bit and says that, like, well, maybe I was in some conversations about how Alameda Research was having this difficulty receiving customer funds. I'd note at this point that he's starting to shift the questions. So, like, the prosecutor will ask this question and he'll give this really meandering reply, and ultimately he'll end up answering some other question. And the judge at this point is also noticing that. He goes, henceforth, listen to the question and answer the question directly. He's like stern about that. They go back to this bank account application for North Dimension, which was signed again by SBF while he was the CEO. He says he reviewed it briefly. He didn't have a lengthy discussion with a lawyer about it. Okay, and at this point, they start asking him, this is when it becomes clear that, like, Dan Friedberg is sort of involved to some extent in this whole trial, because he asks, or he is asked if he reviewed reports of conversations the government had with Dan Friedberg. They do not really elaborate on when those conversations happened or, like, under what circumstances. Was he required to testify, or did he show up on their doorstep? Like, doesn't really say. But it becomes clear that, like, they have at least some access to Dan Friedberg, which is probably not great news for Sam, who is like, Dan Friedberg did it. It wasn't me. It was my lawyer. Just reading the chat. Dan Friedberg was FTX International's general counsel. He was like the head lawyer. What's ASUA? It's AUSA. It's assistant U.S. attorney. And at this point, I think them saying that, like, they have these conversations with Dan Friedberg. Did you review them? He said at least a little bit, maybe some of them, but not all of them. Which seems wild. Like, that seems like an important thing to review. But then again, they've been making all these arguments about how he doesn't have enough time or access to these documents, blah, blah, blah. So maybe he's just trying to say that, like, oh no, I should appeal this because I didn't have enough time to review all these documents in my defense. Yeah, if you want background on Dan Friedberg, go to the previous live stream, which I totally screwed up and cut out of. I did at some point in there give some background on Dan Friedberg, and also there's a great Crypto Critics Corner episode on, the title has something to do with poker's Black Friday, and gives some cool context there. So anyway, this seems to have kind of unsettled him, because the prosecutor starts saying that, well, when we talked to Dan Friedberg, it sounded like he didn't really recall who asked for North Dimension to be created, but that it was either Sam Bankman-Fried or Andy something. Andy K. I think it started with either a K or a C. I lost that. I'll get it on the transcript later. At that point, she asks, is it possible that you asked for North Dimension to be created? And he says he doesn't recall. He had previously testified to saying no, that he had nothing to do with it. So I thought that was not great. Now they get into the topic of the payment agent agreement being backdated. He was, like, overly casual while she asked him that. They were like, when did you sign the payment agent agreement?" He said he thought it was maybe sometime in 2020. Um, she said, "When was the effective date?" And he was like, "It was sometime in 2019." Like, just trying to say, like, as though that was totally normal, and it was, like, obvious that he was trying to act really normal about it. Um And then she just asked him super bluntly, "Did you have conversations with lawyers about Alameda spending money from FTX customers?" And he gets super flustered and goes something like, "I don't recall conversations that were contemporaneous and phrased that way." And then he, like, clutches his water bottle, which is, like, loudly crinkling, sort of in the way this one was, like this. He's, like, drinking out of it, and it's making this sound. It's like, "Oh god, he's so nervous right now." Like, that clearly threw him off, and the way that he said that was just, like, such an awkward, like, long-winded response that there was audible laughter again in the overflow room. He takes a long time to think about answering this question, like, very long pause, and then says something about how he recalls conversations with lawyers about stablecoin creation and redemption. He was like, "I definitely had some conversations with auditors," and it's like, "She wasn't asking you about auditors, my man." But basically comes to this eventual conclusion that no, he had no conversations with lawyers about spending Alameda or FTX customer funds, and that was that. Okay, this was a fun part. Um, they go back to the payment agent agreement, which again is this backdated, like, agreement between FTX and Alameda Research saying, like, yeah, 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 it's totally cool that all these funds are going back and forth between FTX and Alameda. He was like, it was memorializing this agreement that we had before. Critically, this agreement was never disclosed to customers. Or he testified that he didn't think it was. He was like, maybe, we gave it to auditors and they might have disclosed it to the public. And it's like, no, it was not. Um, she just asked him, according to this Alameda Research FTX payment agent agreement, does it allow Alameda Research to spend FTX customer funds? And he's like, well, he's like, I interpreted it to mean that there was a quote fair amount of leeway as long as when a customer wanted their money back, we repaid them. And then he says, I forget how she phrased it, but he goes, I wouldn't phrase it that way, but my answer to the question I think you're asking is yes, which was, again, is Alameda Research allowed to spend FTX customer funds? And she's like, you could just like, you could tell that she was like, oh, yes, because she immediately asks him, they've got this payment agent agreement. They pull it up on the screen and she asks him, can you identify where in the document you thought it allowed you to do this? And there is a minutes long silence while Sam Bankman-Fried is reading this document in front of him. And the woman next to me leans over and goes, stop, stop, he's already dead. And I was like, oh no. And so he's reading, and we're all sitting there in the overflow room like, oh God, this is not gonna go well. And then he finally stops reading. And I'm not exaggerating. I mean, I didn't have my watch. I don't own a watch. I didn't have my phone, so I couldn't time it or anything like that. There was like a dinky clock behind me that I was not watching. But I mean, it was upwards of a minute. And he starts out and he goes, I should preface this by saying I am not a lawyer. And the laughter in that overflow room, we were like, yeah, no shit, my man. Like, you don't have to preface this. And then he goes, the parts of this that jive with that, again, raucous laughter. That's one good thing about the overflow room that you don't get when you're in the courtroom specifically. If you laugh in the courtroom, you're out. The bailiff is like, see ya. Overflow room, there's like, it's a spectator sport. And And then he said, I did not do a careful reading of this document at the time contemporaneously. Contemporaneously was the word of the day. Take a drink every time you hear that word. He's giving this long-winded response about, well, maybe this bit, and he like reads a sentence or two out of it, and I interpreted it this way, and he's doing this whole long thing, and she just repeats, like he finally winds up and is like looking at her like, are we good? Like maybe that worked. And she just repeats the question. Is there a line you can point me to that authorized Alameda Research to spend customer funds? At this point, Mark Cohen, his defense attorney, objects. Basically to say asked and answered. Like she asked the question, he answered it. Let's move along. You're not allowed to just keep asking the same question. And the prosecutor said he didn't answer the question, and the judge goes, agreed, overruled. And then Cohen starts to say something, and he goes, final ruling. So he goes back and eventually finds the sentence that he reads out, which says something along the lines of like, it's something along the lines of like transferring customer funds or something like that. It's not about spending customer funds. And then she asks, did any lawyer tell you you could spend funds? And he says he doesn't remember contemporaneous conversations with lawyers about that topic. We're almost done. I have 3 pages left. Bear with me. All right, now we go into the FTX terms of service. They have the FTX terms of service document in front of them, and they ask them to scroll to provision 8.2.6, which has something to do with it says something along the lines of like, all your funds are yours. We do not take custody of them. You can have them at any point. Like it's like basically saying like, we will not spend your money. And he's like, well, I recall interpreting this as referring only to spot assets. Okay. So again, that's a preview of this defense around, well, they had margin enabled and therefore it was fine that we took all their money and spent it on Bahamian real estate. There's another question around 16.4, which I'm trying to remember what that referred to. I can't think of it off the top of my head, but again, does not recall discussing it with attorneys. It had something to do with, I think that was the part that Can Sun wanted added to the terms of service. It had something to do with the FTX Alameda lending situation. Anyway, can't remember why it was in the terms of service, who added it, where it came from, no idea. He says he did not discuss Alameda's line of credit, allow negative, or exemption from auto liquidation with Can Sun in May of 2022. And then he starts to sort of like caveat that answer where he's like, well, I definitely don't remember talking about allow negative by that name. He says he probably was talking about the line of credit at some point because that's like a normal thing to talk about. He says he's not aware of specifics around exemption from auto liquidation. And at this point, you can see again, the Danielle Sassoon sort of like, she like spots a crack in the armor and she's like, well, let's go into that a little bit. And at this point, the defense starts objecting that she's going too far outside of the scope of the very specific portion of testimony that they were supposed to be talking about today without the jury present. She's asking all these questions about specifics around exemption from auto liquidation, which does not necessarily have to do with lawyer involvement. She makes some explanation for how it sort of is. The defense says something about like, by that logic, anything could be included today. And then at the end, you just ask, did you ask a lawyer about it? And you can get away with it. At that point, the judge does overrule it. He basically says like, well, there's limits and interpretation. And I don't think she's hit the limit at this point, but there were some people in the courtroom who were rumbling about like, it does kind of seem like she's just going to town at this point and not really going with what the purpose of this cross-examination or this hearing was about. But anyway, I can sort of see both sides of that argument. So she's asking him all these specifics around the exemption from auto liquidation. He says he was aware of, like he started talking about speed bumps, and I think the reason that she wanted him to really, um, go into detail on this is because they have that, like, specific tweet, that he sent at some point where he says that Alameda Research is basically treated exactly the same as any other customer on FTX. And so now he's basically admitting that at least as of May 2022, which I believe was before that tweet, he knows that that wasn't true because there was these speed bumps in place when it came to liquidating their positions. And I think he can sort of see where she's going with it. So his first response, which was I think the least guarded response, he says like there was maybe a delay or like there was this manual review process where like if they were about to get liquidated, some pop-up would come up and someone would have to approve it or something like that. And he tried to say that it was all about preventing erroneous liquidations that would, quote, cause chaos on the platform. And he was saying that this came to be because there were points in time where either Alameda was like some of their positions were liquidated or they almost were liquidated in such a way that like the liquidation would have just like totally, I don't know, moved the market or something would have gone really wrong. Maybe there wouldn't have been enough backstop liquidity providers or something like that. And so there was these additional checks put in place. But like he's realizing that he's sort of admitted that he knows that there is this specific, special treatment in place, which was not a great point for him. At this point, she eventually pivots and starts talking about the allow negative flag because she's picked up on the fact that he's like, well, I didn't have any conversations about allow negative in that specific term. And so she's like, okay, but like, did you have conversations about the behavior? Like, did you know that Alameda could run a negative balance? And at this point, he starts trying to answer different questions from the one that she's asking. She starts talking about believing that, first he starts like trying to ask, are you talking about could they go negative on specific tokens or negative overall? And this is something he asked her to clarify several times. At no point was she asking, could they go negative on a specific token? But he keeps being like, but are you talking about with specific tokens? Because I think he wants the opportunity to be like, well, technically they could go allow negative on one token if they were positive on another. But like, she's constantly like, no, that was not what I was asking you. He also continually is talking about net asset value. And at some point, the judge is like, he's like, you've been asked several questions now that at no point included the phrase net asset value. And yet you keep talking about net asset value. Like you are not answering the question that she is asking. Also at this point, it gets to be like, it's like 4:30, which is when the court normally breaks for the day. And AUSA Sassoon basically says, do you want to stop now? This is taking longer than I hoped it would. And the judge says something along the lines of, part of the problem is that the defendant has what I'll call an interesting way of responding to questions. Which, like, yeah, he's wordy as fuck. And he basically is like, we're going to keep going until this is done. Like, I don't care. So we ended up getting out pretty late. I mean, not late, but it was whenever I sent that tweet. It's like, that was minutes after I stepped out of the courtroom. Once again, Cohen objects to the scope of the testimony about this whole negative balance thing. Judge Kaplan overrules him. Eventually, Judge Kaplan did start to crack down, on this like really meandering testimony that Danielle Sassoon was going into, and trying to get her to sort of get back on track a little bit. I think partly because he was hungry or tired or something, like it was getting late and he was like, come on, let's wrap it up. But at this point, Sam Bankman-Fried keeps saying the phrase, I'm going to answer what I think the question you're asking is. It's like, buddy. He also at some point says something he starts to say that the phrase, I apologize if this isn't responsive to the question. He keeps saying that like over and over, or like, I don't know if this is responsive to the question. And eventually Sassoon has to say like, I will tell you if it's not responsive to the question. Like, you don't have to caveat this all the time. It's just wasting time. And there were a lot of things that he was saying that seemed like he was just stalling for time. Like he would say, "Let me attempt to answer that," or something like that, which just was kind of a stalling tactic, I thought. What else? There were some questions around the loans and were they all documented? He said he believed they were, but later learned that maybe some of the later ones had not been documented yet. Um, at this point, it was like Danielle Sassoon. I don't know if she was sick of him, maybe she was over it, but she started to sort of test the boundaries a little bit in a way that I think the judge did not really appreciate. Um, she first starts asking him, uh, did you ask lawyers if it was okay to be taking out loans that were drawing down from FTX customer funds? And he was like, well, no, because he's like, I didn't see that as what was happening. He objected basically to characterizing the loans as drawing from FTX customer funds. That's what they were doing, but he claims that was not what was happening. So he's like, no, obviously I didn't ask my lawyers about that because that's not what I thought was happening. She asks, why were the investments done via loans? He said mostly because the outside parties, but in some cases, Sam Bankman-Fried didn't want it to be Alameda Research that was the investing entity. They gave the specific, I don't know if he offered this or if she asked him for it, but they started to talk a little bit about the Robinhood investment, which he said was made via, basically there was a loan to Sam Bankman-Fried, and then he bought the shares in Robinhood, which were later put in a weird entity that was like kind of under his personal control rather than an investment belonging to either FTX or Alameda, which is why there was at some point some dispute over whether maybe those actually belonged to him personally and he could sell them and then pay for his defense with that. He answered that he did not want the Robinhood investment to happen via Alameda Research because he was worried about conflicts of interest or the appearance of conflicts of interest, because there had been prior discussions about Alameda Research serving as a liquidity provider on Robinhood's crypto platform. So if you don't want there to be conflicts of interest because you're giving a company money from your company that has a conflict of interest, the solution is not to hide where that money comes from. That does not change the potential conflict of interest. It just hides it. So he basically said on the stand that, like, I just didn't want anyone to know where that money was coming from. And then she asks about where the money for the Binance buyout comes from. He says he suspected that there were maybe intercompany loans to do the buyout via Paperbird, and he knows that the US buyout was via personal loan. They didn't really keep traveling down that particular line. And then this is where Danielle Sassoon gets real punchy. They start talking about the topic of safeguarding customer funds because during the defense's questioning, he said, oh yeah, I cared very much about safeguarding customer funds. That's why I was always worried about these hacks. I was being so cautious with these signal chats and, blah, 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 blah. And so she says, she basically says, okay, so, in addition to the things that you described as your attempts to safeguard customer funds, did you acknowledge that there were other ways where it was important to safeguard customer funds? And Sam Bankman-Fried said, oh, I think I got cut off during my previous answer. I only gave one example of how we did that. But there were plenty of other ways, that we were always very cautious about safeguarding customer funds. And she goes, quote, wouldn't that include embezzling customer funds? Oh! At this point, obviously, Mark Cohen objects. It is sustained by Judge Kaplan, who is like, ma'am, that was obviously way out of line. Sam Bankman-Fried answers anyway and says, there's like objection sustained. And then he goes, yes, that would include embezzling customer funds or something like that. And his lawyer was like, when the objection is sustained, you don't have to answer the question or something like that. And like, there's laughter at this point in the courtroom. And Sam Bankman-Fried goes, I felt the need to answer that one, which, again, this was outside of the jury. There was no jury in, watching this. I actually thought it was kind of endearing. Like, that was kind of funny for him to say that, but the jury did not get the benefit of that. Yeah, there was all these questions. They went down the road about talking about these Omnibus customer accounts and his conversations with other CEOs of crypto exchanges about how they handle these customer funds that are put into Omnibus accounts. At this point, I made a joke to the person sitting next to me that like this would be a very, very funny moment for Sam Bankman-Fried to be like, "Oh yeah, they're all just spending customer funds." He did not do that. We can dream. Again, I think a lot of that conversation was kind of mooted by their conversation at a later point where they said that there wasn't really contention over the omnibus accounts and therefore probably don't need to go into it during testimony. All right, last page. Bear with me. Dan Friedberg. Again, Danielle Sassoon gets a little spicy here. For those of you who've read headlines from today's courtroom, I have not read anything yet, but I am sure this has been brought up a couple times. Because it was one of those like dramatic, spicy courtroom moments. She starts asking him about his decision to hire Dan Friedberg. For those of you who have joined late, I discussed Dan Friedberg's background, but he has kind of a shady background. He was working at Fenwick & West, which is a fairly reputable law firm. But prior to that, he was working for a company. I don't know if it was directly prior or at some point in the past. He was working for a company called Ultimate Bet, which was embroiled in this cheating fraud scandal. And he was directly implicated in some senses in trying to cover that up. He was not charged. He was not convicted. There was no legal consequences for him. But like it seems like he was aware of it and helped to at least cover it up, if not maybe facilitate it directly. That's the background on Dan Friedberg. First, she starts asking Bankman-Fried, hadn't you been reluctant to hire a general counsel? And he says, well, I wouldn't necessarily say that. I was worried more about hiring the wrong general counsel than hiring one at all. And the AUSA asks him, kind of spicy, this is not the big spicy moment, but it is a little spicy. She asks him, what I really wanted to ask you was, is it true that you were reluctant to hire a respectable lawyer as general counsel, which was like quite the gut punch to Dan Friedberg if he is, I'm sure, following this case. I forget if there was an objection at this point or not. I think there was, and the judge overruled the objection, but did add the caveat that like, I'm not endorsing the use, the implication that Dan Friedberg is not a respectable lawyer. Like he obviously was like, oh, that was a little, he's not trying to insult Dan Friedberg, even though Danielle Sassoon might be. At this point, he says something along the lines of like, I don't recall ever having said that, but had I said such a thing, I would have meant, and then he goes into this explanation about how, he didn't want a general counsel who would stop the company from taking risks that were within the bounds of the law, but like, crypto companies are risky. And so, we need a counsel who's okay with that. Obviously, he wants a counsel who will make sure that we are totally within the law, but like, there has to be risk tolerance. It was a very sort of OJ Simpson moment, like a if I did it type of thing. Like if I had said that, I would have meant, which I was like, yikes, my man. And then Danielle Sassoon asks him, were you aware that Daniel Friedberg had previously worked for a company that had suffered a high-level scandal? Again, I think there were objections at this point, eventually overruled. And Sam Bankman-Fried said he was sort of aware that there was like drama at his past company, but he wasn't sure he knew that much about the specifics. And then she says, were you aware that Daniel Friedberg's companies were involved with criminal scandals? And at this point, there was an objection which was sustained. She tried to argue it a little bit with the judge, saying like he opened the door because he said, well, he knew there was something going on, but never got to hear the answer to that question. And then, this is the real spicy moment. She asks him, were you aware that Daniel Friedberg at one point used illegal narcotics with your employees or with FTX employees? And everyone in the courtroom was like, or in the overflow room was like, oh, fuck. Objection sustained. And I think the judge actually scolded Danielle Sassoon at that point. That was like, let's move on, like she was trying to impugn his credibility, but like I don't know to what extent you're necessarily allowed to do that when like he's not the one on trial and blah blah blah, but like she did not specify which narcotic. I would be very curious to know which one because like I'm pretty sure don't some people consider weed to be narcotic? Because I would have a different opinion of that. Or like, I don't know, maybe he was out there doing all this Adderall, which is, I guess, illegal if you don't have I don't know. But like it did not sound good. Let's just go with that. Did not speak to his credibility. But she was again, there was an objection. It was sustained. The jury was not in the room, and so this will never really reach their ears, as far as I'm aware. It was at this point it was 5:00, and they finished up. There was, I think, one or two other questions. We did not end on that note, which would have been funny, but there was like only a couple questions because the judge was like, we don't need to go into his drug use. Now, at this point, the defense is asked to basically make the argument for why they should be allowed to bring all this evidence, and the prosecution is asked why they do not want this to happen. And the judge, I forget if this is before or after they give those statements, but the judge is like, I'm going to ask a multi-part question here. And he lays out this hypothetical scenario where, okay, let's imagine that this guy, he robs a bank, he robs a Walmart, whatever. Maybe he finds a bunch of some company's money just laying around and he decides he should squirrel it away somewhere. And then he goes to a lawyer and he says, I've got this condo I want to buy on Billionaire Street or something like that. I want you to form this LLC and buy this condo, and basically tells him nothing about where the money comes from. He's like, how is that different? Basically, if that was the case, you can't argue that like it's okay to rob a bank because you later had a lawyer write up this document for you to buy this condo. And so the judge was like, how is this different from all of these legal documents that you're pulling out here that show that a lawyer, wrote up this promissory note for a loan or, whatever it might be. And this definitely was like, Cohen answered the question, but it was not a very convincing answer. He basically was like, well, it wasn't theft. Like the money wasn't stolen. He was allowed to use this money. And so it's totally different because he didn't rob a bank. And the judge pointed out that like, that's a question of like the merits of, the theft or lack thereof. It's not like, that's a whole different argument. That's not relevant to this whole legal stuff. And so they went back and forth on this a little bit. The judge ultimately decided he's going to rule on this in the morning. So we don't know yet whether or not some of this testimony that happened today will be repeated tomorrow. Again, I did not find the defense team's explanation for how this was different from robbing a bank to be really that convincing, because again, it's like they're going to make that argument. They are making that argument that he didn't steal the money, that it was a totally acceptable use of the funds that he had access to, and therefore no crime. But like that is a separate question of whether or not he can introduce all these legal documents. And again, I said this earlier, but like it does really feel like he's trying to just sort of like squeak in this advice of counsel defense without making a formal advice of counsel defense. And I think the prosecution is noticing that. The judge is noticing that, obviously, because the prosecution is objecting to it. And so that's the whole thing. I mentioned this earlier. The last thing they talked about was whether or not Sam Bankman-Fried is allowed to bring up this subpoena that they sent to Fenwick and West. Again, the FTX bankruptcy team objected to it, and it was ultimately rejected. But they did not serve a trial subpoena, and the prosecution feels like they sort of didn't work that hard to try to get this document, and therefore can Sam Bankman-Fried, if they start asking about this and Sam Bankman-Fried starts saying what he was saying today, which was like, unfortunately, I really wish I had access to this document, but unfortunately, like, there's no, I just don't have it because, these guys aren't giving it to me or whatever. They were like, can he really say that when they haven't really tried to get this document? And I think the judge ultimately decided that, like, he can say that, but at that point, the judge can point out, he can make, basically, I forget what they call the comments to the jury, but he can basically tell the jury that, like, they never served this trial subpoena. So like I said earlier, I suspect Sam Bankman-Fried's defense team will tell him, let's sidestep that particular excuse, because otherwise it'll just make us look bad and like we were intentionally trying to avoid having this document brought up. If they were to get access to this document retention policy, I think it would be quite useful for the prosecution, who I think tried to present it to Sam Bankman-Fried and get him to testify that the document that they had was the accurate document, which he refused to do. So as far as I can tell, that means that, he won't stipulate to it. I don't know if they have anyone else who can attest to its legitimacy. They've already brought their witnesses and didn't address that then. I don't know if they can just go back and do that, even if one of them could attest to it. So anyway, long story short, there's some question about that, but we'll see where it actually goes. Okay, I did it. That's all my notes. I had so many notes, and I'm sure I will have so many more tomorrow because Sam Bankman-Fried talks really fast. The transcript today is probably going to be about a bajillion pages long. Actually, it's probably in my inbox by now. Hell yeah. I'm just curious at this point how long it is. Today's transcript is 246 pages long. That's actually not as long as I expected. There have been some days where it has been around that long. But yeah, it was a long day. I'm a little zonked at this point. So tomorrow, what's on the docket for tomorrow? The defense team is going to question Sam Bankman-Fried on the entirety of what they hope to talk to him about. I believe they estimated that it would be, so at some point before the defense began putting on their case, they told Judge Kaplan, who is just trying to like estimate scheduling, that they thought it was going to be, I think, 4 hours, maybe 5. He asked again at the end of the day, does that still feel accurate? And they said that they wanted to, he's like, I'm not going to hold you to it, but they still didn't want to estimate. They were like, we want to talk to, I think they wanted to talk to Sam Bankman-Fried about it. So tomorrow they said they would have that estimate. So I have no idea if that's changed or not. But I believe it was at the end of the day when the prosecutor said that she thought it was going to be 45 minutes of cross, which seems insane to me because, I feel like when did they start? I feel like the cross-examination they did in just the hearing today took 45 minutes at least. So like, if we assume that all of that is let in, do they not have anything else? Or maybe she was referring to the rest of it, like there was going to be however long this took plus 45 minutes. Yeah, cross-examination started at 2:15 and we got out at 5. So like that math doesn't work. So maybe I misheard her, or maybe it was what I was just saying, but we'll see. I'm really hoping that they tighten it up tomorrow because I don't want this to go into Monday because I want to be there to see it. The transcripts have been great. I have found them to be quite useful. You definitely lose a little bit of the tone. You don't get to see the jurors, but you don't get to see the jurors in the overflow room either. You lose some of the timing and that kind of stuff. It's a little harder to tell what really lands and what doesn't, but they're pretty good. And I feel like there are huge advantages to reporting on this trial without having my cell phone and my internet access removed from me for 8+ hours. That the other journalists here don't necessarily have. I don't know how they do it. Maybe I am a wimp, but I'm tired after today. And I remember I stepped out of that courtroom yesterday. See, I'm already talking crazy. I stepped out of that courtroom this afternoon and I was like, the idea of trying to write a newsletter right now it seems impossible. But, like, there are all these reporters who've been here for this is week 4, and, like, they've been filing every night, and it's like, "Oh my god, I do not have that stamina." I asked Nick today, like, "When do you sleep?" Because, like, I was asking him some question last night about, like, what time I should show up today or something, and it was, like, 12:30, and then he was there bright and early before I was, so I don't know how he does it, but anyway, I am not that impressive, and capable, so anyway, I will at some point write up a newsletter about everything that happened today because I know that the vast majority of people would not like to read or listen to 4 hours of me yammering. But it will not be before I return, I'm sure. Same thing about tomorrow. So if everything goes according to plan, right after the testimony, I'm going to like book it to the airport and head home. Which means that I will probably have, I'll write on the airplane a little bit, but the flight is not that long, and so it'll probably be Saturday before I publish whatever happens tomorrow. I don't know, I might try to do something along these lines because I'm sure it's going to be bonkers. Today was already kind of wild, and it was like not even the real thing. It was like the practice run. So yeah, but anyway, appreciate y'all sticking around and listening to me yammer in lieu of reading something far more polished and concise. Let me just scroll up a little bit to make sure I get any last minute questions before I sign off. Someone asked around, oh yeah, so like what happens tomorrow around the stuff that they already covered today? I don't know. So I'm pretty sure they're gonna just have him answer everything again. I don't think they're just gonna like read off the transcript because that just seems like they would miss a lot. So I assume they're just gonna have like take 2. Hopefully he'll be quicker and maybe practice a little bit tonight. I know he gets the opportunity to meet with his attorneys a little bit after trial and in the morning before trial. So maybe he'll polish up some of those questions. I assume that, I mean, he was under oath. So like, I assume if he says something that's totally different from what he said yesterday, they could try to, you know, impugn his credibility or something like that. But I think he goes again. Unfortunately, we probably won't get that like very pregnant pause of minutes while he was trying desperately to find a line in the payment payment processing agreement that said that he could spend Alameda customer funds, because I thought that was pretty that left an impression, and the jurors did not get the benefit of that. So tomorrow, I mean, he'll probably just jump right to the line if they ask that question again, but that didn't go well. What else? Hiding crime is still a crime. Yes, that has been mentioned several times. The other thing that keeps coming up is that if you steal money and then you make money from the money that you stole, you still stole the money. So that keeps coming up with the topic of Alameda Research made an investment in a company called Anthropic, which is doing AI stuff. And AI has been the hot big thing. And so I think it was a $500 million investment. And now Anthropic is raising another round. And it sounds like they're going to be valued at like some billions of dollars. And so it could be that Anthropic investment actually turns out pretty well. And, it could actually help to repay some of the bankruptcy creditors, which is great. Like the best case scenario here is that Sam Bankman-Fried is held accountable for his crimes, and also all the customers get their money back. Like that is the dream. But they have had to repeatedly remind the defense team that, yeah, you stole the money and then you made a good bet and that bet paid off does not mean that you never stole the money. The judge actually made an analogy. He likes his analogies, and he made an analogy that was like, if I rob a bank and steal $1 million and then I use some of that money to buy Powerball tickets and I hit the jackpot, I still robbed the bank. It doesn't make robbing the bank okay. So that's the other thing that's having to be mentioned repeatedly. Yeah, they've not mentioned that Joe Bankman recommended Friedberg. And there was one other point. Oh, there was a point when they were talking about why all of these uh, investments were being made using loans. Like, why didn't they take, dividends, or I forget what exactly they were talking about, but like, why was it loans? And Sam Bankman-Fried said something along the lines of like, there was concerns that if we structured it differently, we might get taxed double on it. And then they asked him, which lawyers did you talk to about that? And I was like, oh my God, I wonder if he's going to implicate his dad at this point, because we know that Joe Bankman was giving him legal advice at various times. And Joe Bankman is the Stanford tax law guy. Like, that is his field. He was probably giving him advice on things that there were tax law implications on, but he did not mention that. I think he said it was Dan Friedberg and Ryan Miller or something like that. So that would have been crazy if he was like, oh, that was my dad who told me that was okay. Hopefully the defense will tell SBF testimony is a bad idea. Boy, I mean, I felt like he was flustered today, so I wondered if he was reading the room and getting the sense that it was not going well for him. Everyone in the overflow room sure was. Like, there were points where everyone was looking around like, that's not going well, Um, but something tells me that even if he can back out now, and I don't know if he can, I think he can, um, he will not choose to, because I think he is at this point so determined that this is like his last chance to fix everything, and he's going to get a not guilty verdict or something like that, which I think is just not going to happen. Transcripts. Yes. Okay. So question on the transcripts and how to get access to those. So there's some weird stuff around court transcripts, and I hate this as someone who is very keen on open access and loves to link my sources and stuff like that. But court transcripts have a 90-day restriction period on them, where you can only access them by buying them from the court reporters, and they're expensive. They're expensive. Um, or through like showing up in person at the courthouse, and they have these terminals where you can look at them, and you can't print them out, but you can look at them. And I don't think you can like take pictures of them. Maybe you can. So I have access to them. I am paying for it. It's not super expensive through a thing that's been set up, but I can't share them. I can't even share screenshots from them. I can quote from them, but that's it. And I'm trying to be somewhat judicious about how much I'm doing that, because I understand like this is a lockup thing. I've tried to figure out why this restriction exists. I think, and I spoke to some people who are fairly knowledgeable about both open access to court records and law, and I'm pretty sure it's kind of a multi-part thing where one, there is a period of time where they can request redactions to these transcripts. And so if someone says something in the courtroom that is, should not be in the public record for some reason, you have that 90-day period to request that redaction. Obviously, there's a risk that a journalist or someone else who's bought this transcript already will get access to that information. So like, it's limited, but it does help. But I think also it just has to do with like, this is how court reporters make money. Like, people will buy these transcripts. And so this 90-day period allows them to charge for copies of transcripts that would otherwise be freely available. So I think after 90 days, they become part of the public record. I don't know if they go on PACER. PACER is the public access to court electronic records. I don't know what the E stands for off the top of my head. You often will notice that I link to a site that's called Court Listener. Love them. It's an initiative by the Free Law Project that basically you can download this extension for your browser. And anytime you go on Pacer and you buy access to a court document, which is like 10 cents a page or something like that, there's this like fairly modest fee. And it's capped at like $3 or something like that. So even if it's like 1,000 pages, you don't pay more than that. It basically yoinks that file from your downloads and throws it on Court Listener. And so then at that point, once one person is paid for it, everyone gets it for free. So that's why I like to link to Court Listener because then you don't have to pay, like otherwise everyone would have to go to Pacer and pay 10 cents a page. So Court Listener is great. I assume transcripts maybe go to Pacer after 90 days, at which point people can buy them and or upload them to Court Listener. I'm not sure. But the long story short is that there is no free access to them at this point, and I can't share them. The government exhibits I do have access to. They are not publicly available, but I was able to get access to them as a journalist. They didn't ask for like a press pass or anything, so I was like, okay. As far as I'm aware, there's no restriction on sharing those, although it's not been made super clear to me on that. And so I'm trying to be, again, kind of judicious about which ones I share. I have been sharing some of them, and I have uploaded some of them in their entirety, because there is, like, I was told explicitly about the transcripts, like, you cannot share these, whereas people are pretty broadly sharing these court exhibits. But again, I'm just trying not to like get in on the bad side of the people who are kind enough to share access to this stuff with me. That was a long answer to a short question. Okay, let's catch up a little bit more. Now is the time to get your questions in while I'm catching up on other questions. Oh, hello to Spain in the middle of the night. Oh, thank you for saying you like my blog. I read just enough Spanish to understand comments like this. How the hell could your notes be that detailed? I write pretty fast. My hand hurts. Again, I have not taken physical notes in a very long time, but I do my best. Thank you all for who've said that you are paying for your Substack subscriptions. I mentioned this earlier, but it makes a huge difference to me. The only way I was able to book a flight and a hotel at the last minute was because you guys have been lovely enough to support the work that I've been doing on Substack. I don't think I mentioned this recently, but some of you probably know I am a fellow at the Harvard Library Innovation Lab, who have been wonderful in supporting my work for the last year. I started that in November 1st of 2022, and it was a year-long gig. So I am several days away from the end of that, which again, it has been lovely, but it also means that my sort of other half of my income is going away pretty soon, and I am still deciding what to do after that point. So I would love to keep doing Substack and this type of sort of the random things that catch my attention work that I do, and I'm hoping that that will be financially feasible for me. We'll see. I might otherwise start, I don't know, doing freelance software or something like that. We'll see. I don't know. But anyway, again, just wanted to reiterate that those of you who do pay for subscriptions are amazing. And I am just floored that it is even possible for me to be in New York City and also consider just doing Substack for at least a month or two, if not potentially longer. Is Sam Bankman-Fried the last to testify before the jury decides the outcome? Yes, he is the last witness. There will then also be closing arguments. So both the defense and the prosecution will have a chance to stand up and sort of summarize everything that has happened during testimony and sort of tell the story of what really happened. At that point, after that, or maybe before that, I think after that, the judge will give jury instructions. And so there's been some back and forth around that. Both the prosecution and the defense have made arguments around what should or should not be included in the jury instructions. One example is that like the prosecution does not, or no, the defense does not, the defense wants the judge to make some statement around like, just because something seemed like it was morally wrong doesn't mean it was a crime. So it's stuff like that. I think ultimately that is up to the sole discretion of the judge. He's the one who gives these jury instructions, and he can or can choose not to include the stuff that is recommended by either team. And then at that point, the jury begins deliberating and potentially returns a verdict within who knows how long. I mean, it could be hours, it could be days, it could be a week. I don't know. I will actually be traveling again, believe it or not, in a week and a half. And so I am really hoping that they're nice and quick, and that way I don't have to try to report on the verdict from elsewhere, but we'll see. I will make it work one way or the other. hire a TaskRabbit to stand in line. Oh my god. That's a good idea. I'm not gonna do it, but that's a good idea. How long is the trial estimated for? That's a great question. So the closing arguments are not supposed to take super long. This is not like a multi-day thing. Jury instructions similarly should not take long. I think they're expecting that they'll probably wrap things. I mean, again, the defense wanted to converse with Sam Bankman-Fried before giving an updated estimate on the timing, but unless something dramatically changed, it seems like they will probably wrap up his testimony on Monday. Again, could be Tuesday. The defense seemed like they were being awfully optimistic about how long it would take them, especially given how verbose he is, but that's my guess. And then closing arguments, and then the jury will deliberate. So it could be pretty soon. Maybe they can show excerpts of video from today's testimony. I do not believe so. I'm not even sure if the video that is shown is recorded. I feel like it's just the transcripts. They're really very strict about video recording and stuff, which I kind of understand. I mean, I definitely remember thinking at some point today, it was during one of those really wild moments where, like, maybe it was when Sam Bankman-Fried was like looking for the answer in his document or something like that, where I was like, man, this shit should be televised. Everyone deserves to get to see this. But like, I get that, like, they don't want criminal trials to turn into this huge spectacle where people are like acting for the camera. Obviously that happens anyway. Like, everyone knows there's journalists in the room and blah, blah, blah. But like, I do sort of see the point on that. But yeah, I doubt that they're going to just show the jury the video of what happened today. Is it usual for defendant to directly speak to the judge instead of in front of the jury? That's a great question. So the hearing that happened today, the judge said something like, there was some question right at the beginning of it where the prosecution was like, how do you want us to, make our objections? And the judge was like, I don't really have a playbook for this because it has been years. Or even he said something like, I'm not sure I've ever done a hearing like this. So this was unusual. I'm not sure why it was unusual, but it was apparently unusual. Do I think either of Sam Bankman-Fried's are criminally liable for anything? Yes, it definitely seems like that. I based that opinion on the lawsuit that was filed by the FTX bankruptcy team, the debtors basically, against his parents, which suggests that Barbara Fried may have been involved in some of the straw donor stuff, the campaign finance violations. It seems like she was sort of instructing some of those donations to be routed through employees who weren't Sam Bankman-Fried, which is not great or legal. And then there's Joe Bankman, who seems to have been much more involved than either he or his son would like to admit. And I think Sam Bankman-Fried is trying to protect both of them. He has been very reticent to mention Joe Bankman in any way or the advice that he was given. He's acknowledged that he was present for some meetings, and there have been exhibits brought where it shows that Joe Bankman was like a member of some of these signal chats and stuff, but like that is the extent to which he has been brought up in this trial. But I think if they wanted to, they could bring charges against Joe Bankman and Barbara Fried. I don't know if they will choose to. I think just like from an optics perspective, it would seem like bouncing the rubble, maybe. I don't know. Like, it just seems like overkill to go after his parents too for what were fairly minor crimes. I mean, they were crimes for sure, but like they are somewhat elderly. I think they're pushing 80 maybe. And I just don't necessarily see that as likely. But I do think it is very possible that the $10 million gift that they were given and potentially other things will be clawed back by the bankruptcy team, which is going to be devastating for them, especially because I believe there is at least strong speculation, if not confirmation, that Sam Bankman-Fried's defense is being financed by his parents. And his parents are not independently wealthy. They're professors. They're not, scraping by, but they don't have millions of dollars, and his defense costs millions of dollars. And some of that is coming from directors and officers insurance, so that is being paid by FTX, but some of it is not. And so, those millions of dollars gotta come from somewhere. It could bankrupt his parents. Doodly-doo. Oh, yeah, there's a question about who's paying Cohen. Just answered that. Woo. My scroll just jumped around. Oh, thank you for giving the correct acronym for PACER. They're not copyrighted, no, so they should be freely distributable in 90 days. The transcripts, that is. Yes, it is federal court that is so precious about video streams. There are definitely state courts that stream stuff. I'm sure you've seen videos of various testimonies and stuff. That is because it is in state court. Did Sam Bankman-Fried seem like his usual self? I thought so. He has a very sort of unique demeanor, and that was definitely coming through. He definitely sounded like I remember him sounding around the time of the FTX collapse, which is obviously different from how he was talking publicly while things were still going well and he was still a billionaire on paper. But yeah, he seemed his usual self. He seemed alert. He didn't seem drugged up or anything like that. I know some people are like, he's on speed and stuff like that. He was normal. Did I hear Lewis is starting to turn on Sam? Is Lewis a victim? I had not heard anything about Lewis's more recent statements. I mentioned this earlier. I know he has a podcast. I have not had the opportunity to listen to it, but I very much would like to. I'd be very curious to hear how his opinion has changed. I might get the chance to talk to him tomorrow. Like I mentioned, that could be kind of awkward depending on if he has read my review of his book, which was a little bit critical, as my writing often is. And also whether or not he feels like that was rude of me to do because he invited me on his podcast. I don't know how he feels about that. Like, part of me worries that he feels like it was like a betrayal or something like that, which, I don't feel like it was, but it could be that he feels that way. But anyway, I'd love to say hi to him and also just pick his brain about how he feels about the trial. Oh, I can't wait to read Liz Lopato's piece. Her coverage, I called out Nick Day's coverage as being really good. Hers is also extremely good. Like, if you read two other people besides me, it should be those two. Yes, I'm also very curious how the inner circle who cooperated will do. Two of them, I want to say it was Gary Wong and Nishad Singh, both said that they're hoping they won't get any jail time. I don't know if that's realistic, but I'm sure that they will get considerably less jail time than Sam Bankman-Fried. It could be, I don't know, 5 years or something like that. I'm pulling that out of my ass. I have no idea, but their cooperation means a lot, I think, and Sam Bankman-Fried's lack thereof is not doing him any favors. Oh, I was off by about a decade on Joe and Barbara Fried's ages. Huh, I would have guessed they were older than that. Why does it matter if his parents are old? It doesn't. A crime is a crime, but I think that it is more publicly accepted to charge someone who is not facing a very real chance of dying in prison. I think that, a serious crime, they will do that for sure. I think for like a campaign finance violation, they might not. Again, uninformed opinion, not a lawyer, just my 2 cents. Yeah, I found that was weird too about my conversation with Michael Lewis because I had not talked to him before. Literally, like when I said hello to him at the beginning of that podcast, that was the first time I've ever spoken to him. I had spoken to like his assistant beforehand, and they did what often happens with podcasts where they give you just sort of an idea of the topics they want to cover. But we didn't really talk about Lewis's opinions on things, and so from his side of the conversation, he sounded very skeptical. He was like, I don't really get Bitcoin. At some point, he made some joke about how it was kind of pointless, like a mountain unicycle, which was funny. It seemed to me like he was a crypto skeptic. And then, this book comes out and he definitely is not pro crypto in the book, but he is pro Bankman-Fried, I think. And I should say that, like, I don't wanna overstate how friendly the book is to him. I do think it was very friendly, and I quite I stand by what I said in my review. It doesn't make Sam Bankman-Fried come off like a nice person or a likable person. Like, you don't read the book and go like, "Hell yeah, I wanna go get a beer with that guy." But he does try to make the argument that he could very plausibly be innocent. It's like he's an asshole and he doesn't care about other people and he has no empathy, but he's innocent. So it's not a glowing profile by any stretch, but I mean the important part is that he did the crime, right? And so um I was surprised when he ended up publishing a book like that, and especially actually, I feel like some of his public statements around the time of the book release were even stronger than some of what he says in the book. Like when he said that maybe the money's all there, or there's a Sam Bankman-Fried sized hole in the world, or something like that. Like that was crazy. That was wild. And so then I read the book, and I was like, okay, I mean, this was a lot, but he didn't say there's a Sam Bankman-Fried sized hole in the world. Anyway, it was strange. I'm really curious, like, what led him to believe that. I mean, it seems like he was really taken by Sam. Yeah, restitution could be huge, although I wonder to what extent they even have the money left. Um, a lot of stuff has already been clawed back, but yeah, I mean, bankrupt potentially, for sure. What's the arrangement involving how his testimony will or won't be shared with the jury? So the judge will rule on what can be included tomorrow morning. So we won't hear about that for another couple of hours. But like I said, I'm not 100% sure about the specifics of this. I'm pretty sure that Sam just redoes the testimony. Like they ask him the same questions. And I think I said this earlier, but I think if he says something that contradicts what he says today, they can still bring that up. They're allowed to say, like, you told us something totally different yesterday, and that's a potential lying under oath thing. But I don't think they're just going to like read the testimony. Someone asked if they're going to play a video. I don't think that's going to happen. Pretty sure they go through it all over again. So it was a nice practice round for him. I mean, in that sense, that was probably good for the defense. How much of Sam's behavior attributed psychosis from drug abuse? I think those. Oops, not again. I won't. I promise I'm not going to unplug my video again if this happens. All right, I'll just be blurry for a minute. I think a lot of the theories and speculation about drug abuse are a little bit overblown. It seems like he was maybe more amped up on Adderall than he should have been, but like he does seem like he has some amount of ADHD. Whether he was overprescribed or I have no idea. I'm not a doctor or anything like that, but I don't necessarily think he was like totally methed up and going nuts. I think he is just kind of like this. And like the conversations that have been had about his opinions on ethics and utilitarianism and effective altruism, and like, I mean, he's had those for a long time, and I don't know if he just like I just don't buy the idea that he was just really cranked up on Adderall and went off the rails. But also, that's not really a great defense either. Like, you can't just be like, "Whoopsie." I guess if it was like proper psychosis, maybe you could make an insanity plea, or an insanity defense, I guess, but that's not happening here. Any institutional customers testified so far? So they've had lenders, and then I don't know if they've had like any of the trading firms that were on FTX, maybe. Yeah, I'm trying to think. They definitely had. I mean, they had BlockFi and that kind of thing, and then they've had individual customers. Where is all the money? Well, currently it's being clawed back by the bankruptcy team, but a lot of it went to real estate, a lot of it went to venture investments, a lot of it went to loans, which were then used for the aforementioned two things, and also political donations, charitable donations, gifts to family, friends, a lot of stuff. That's something I was actually talking to someone about that earlier today when we were talking about Michael Lewis. Is like one thing that really annoys me about this whole thing about like I think the money is all there. Like they never spent all the money. Look at how much money they have. The money is all there because the bankruptcy team is clawing it back. Like they had to declare bankruptcy to get the money back because they spent it all on venture investments and real estate, and that's all being clawed back. And so, yeah, the money is there. That doesn't mean he didn't steal it and spend it in the first place. Like that drives me crazy. Yes, I know restitution will follow them around. Um, but like, I'm not sure how lucrative a career Caroline Ellison or Gary Wong or Nishad Singh will have after this, right? Like, I mean, this is a tough reputation to overcome. What is the best way for us to continue to support you and your work? That's very kind of you to ask. Substack subscription is huge. If you don't, I know some people really don't like either a Substack or they don't like recurring donations like auto renew and that kind of thing, which I totally get. So if you're not big on that, I also have a donation link that you can use. I don't know it off the top of my head, but if you go to my Twitter, it's in my link tree. Or if you go to web3isgoinggreat.com, there's in the top header, there's a contribute button and there's some more details in there. Thank you. That's very nice of you to ask. Mighty Nine reunion. I'm so excited. I will definitely not be listening to that tonight because I will probably turn on the episode of Bell Cells that I've been listening to, which I keep falling asleep in the middle of. But at this point, I have this like Pavlovian thing where as soon as Matt Mercer starts talking, because I listen to Critical Role when I fall asleep, it's like Matt Mercer puts me to sleep. It's amazing, but it also makes it challenging for me to get through more than like 15 minutes of an episode. Did it touch upon effective altruism? Not a lot. It did not come up a lot. And I think the defense was actually maybe precluded to some extent from making that argument that like, oh, he was trying to do so much good. It's fine. It was all about this effective altruism thing. It came up to some extent, but it was limited. I don't think they even really told anyone what it was. Yes, BlockFi was technically a customer. That's true. He did speak. Actually, now that you mention that, he did speak to both aspects of it. Where's Trabuco? Will we hear from him ever again? That's a great question. I do not know where Sam Trabuco is. He is either in international waters on his dumb little boat, or he's got, I don't know, some sort of agreement, or I don't know what's going on, but it is weird that he is just not around for this. I mean, yeah, I don't understand. I have not read Mauschewitz's stuff on SBF FTX. Feel free to send a link though. Despite the fact that I follow this so closely and read hundreds of pages of transcripts, I love reading coverage of this trial because it's like, I know it's so well at this point, and like all of the background, that reading other people's takes on it is like such a fun way to get a cool, like a good sense of their ideas and their opinions. And it's just like, I have a great sort of baseline frame of reference. And so it's like extra interesting to read about it, even though it seems like it might be repetitive. I love it. I have been voraciously consuming reporting on this. You should make my various websites link to my Substack. I think they do. Like if you go, they might just be kind of hidden. Like if you go to my mollywhite.net site, I think it says like I write a newsletter and like that's linked and it doesn't mention Substack. But yeah, maybe I should make it more prominent. It would be a fairly bad argument. Cases I wish I could cover in more depth, but can't because they're just one person. Yeah, I mean, there's a lot of cases happening right now. I feel like I haven't gone super deep into Ripple, but I also don't know if I have the stamina for that. That one's just like so in the weeds and so, what's the word? Zealot. It's like there are zealots on both sides of that one and it's exhausting. So I don't know if I necessarily want to cover that, but I haven't covered it very much, and I kind of feel like I should. Um, any criminal crypto cases, I think are going to be fascinating. The great thing is that they don't seem to all be happening at once. And so, like Sam Bankman-Fried is on trial right now. Obviously, I believe Alex Mashinsky is due to be on trial in like about a year from now. So stay tuned. Maybe I'll be back in New York covering the Mashinsky trial. I don't know. Um, but yeah, and then, there's other ones, but the other ones, I don't know where they're gonna happen. Like, Do Kwon is in Montenegro right now. They're trying to figure out if they want to extradite him to the US or South Korea. If he's in South Korea, I love you guys. I'm not flying to South Korea to cover the Do Kwon trial, which I probably won't even be able to understand. And same thing with Suzu. Like, I think he's in Dubai? I don't know. So yeah. But yeah, I'm jazzed for the Alex Mashinsky trial because Alex Mashinsky reminds me of Sam Bankman-Fried in some ways. I was actually talking to someone about this today. He has that. In fact, he's more arrogant, I would say, than Sam Bankman-Fried. He's very arrogant and very sure of himself. And I wonder if it will result in sort of a similar spectacle as to Sam Bankman-Fried, who, like, by all accounts should have taken a plea deal, but decided that he could beat this, I guess. I think Alex Mashinsky is maybe somewhat more willing to listen to lawyers or like realize that it's a bad idea for him to try to go to trial or something. So maybe those hopes will be dashed, but yeah, we'll see. Do you think when you started down this crypto rabbit hole that you'd end up being a de facto crypto reporter? Absolutely not. When I started my Web3 is Going Just Great website, I thought it was just going to be like some funny thing I did to entertain myself that no one would care about or read. And I was pretty shocked when that turned out not to be the case. And I certainly did not expect to be doing this, but have had a wonderful time doing it. It has been an absolute blast. I love software, don't get me wrong. I had a really great time being a software engineer, but this has been a lot of fun. And so, yeah. If Sam runs over to Monday, are you going to try and stay longer in New York City? So I could. I can beg and plead with my poor dog sitter. I can try to swallow my own sadness at being apart from my beloved dog. And I do still have that refundable ticket to come back home on it. It was scheduled for Tuesday, so I could use the return portion of that ticket to come home. I would eat the cost of the return ticket I bought for Friday, but that's not the end of the world. The flight was actually much cheaper than the hotels. The hotels are what get you. I would have to find a hotel, which would be expensive. But anyway, I'm going to do everything I can. That's not true. I'm going to hopefully not be here. I really don't want to stay here this weekend. And I am very much hoping that cross-examination does not get delayed until Monday or substantially happen on Monday. But there's some chance I could stay if that seems like the decision. So we'll see. Why is Mashinsky's trial a year off, but Sam Bankman-Fried was so quick? Sam Bankman-Fried, his case was wildly quick. Like that, it was unusually quick. I think maybe in part because they had a really strong case against him, maybe because it was so high profile. But I think it's actually Sam Bankman-Fried's case that is the outlier and maybe not Mashinsky's. And yeah, Sam Bankman-Fried's team also wanted it to move along. Like there was an opportunity when he was making all those arguments that like he's not getting enough access to his defense materials or his defense team. The judge repeatedly was like, you haven't asked to delay the trial and you could. Like, are you sure you don't want to do that? And they were like, oh, no, we don't want to delay the trial. So they clearly wanted it to move along as well. Yes, and these things can go on for years. Although I think that's maybe more likely for like the bankruptcies and stuff like that. I feel like with the individual criminal cases, it's a little speedier. Are you going to go outside crypto reporting? I love crypto reporting. Honestly, people are like, when are you going to go into AI? And like, AI is interesting. I think it's fascinating, and I see a lot of parallels with the crypto stuff, but it's crypto that I think is really fascinating, and so, I'm not planning on branching out. Although I do occasionally write stuff that's sort of just, like, about tech more broadly, or, like, I did that piece about venture capital, which was really fun. If I had one of those Harry Potter time turners, I would write something about that Andreessen Horowitz psychotic manifesto that, Mark Andreessen published recently. I also find Andreessen Horowitz to be fascinating as, like, a microcosm of some of the worst things in tech. Uh, IPFS, fascinating, I will say. Yeah, there are these things around sort of the fringes of crypto and, like, Web3 that are really interesting that I haven't had the opportunity to write about, which I would love to. I also really want to write something about effective altruism soon, because obviously that's come up a lot. I feel like I kind of missed the chance to do that. Like, I should have done that a long time ago, but might still be worth writing at this point, because it's one of those things that, like, it sounds like a good idea. You're like, oh yeah, effective altruism. I want to be effective with my altruism, and then you look into it and you're like, oh my god, this is deranged. So I don't know if they invoked his right to a speedy trial per se, like that specific thing, because I think that's, like, really quick. But this trial schedule, I think, has been set for a while. I don't think it was changed based on his bail or bond being revoked. Is there any chance that we're going to see the new AI moguls wind up embezzling money like crypto moguls have? I mean, where there's money, there's fraud, right? That's just how it works. I think crypto did help a little bit, just in the sense that, like, it's really easy to defraud people when you have cryptocurrency involved. Um, but I am sure that there is fraud happening in the AI world too. The thing about AI fraud, though, and one thing that I think makes it less compelling for me to cover compared to Web3, is that, like, a lot of the crypto Web3 fraud was on, like, normal people. Like, retail folks were being told, this is how you can make a big buck, whatever the story was. With AI, it's like, it's venture capitalists who are getting screwed over, and I don't really care that much about what happens to them and their money. Like, it's whatever. So that's one thing I think that just makes it a little bit less compelling for me. Yes, I think also effective accelerationism would be a really interesting topic. Do I have a formal or informal education in philosophy? I do not. I have neither. I have a formal computer science degree. That's it. What happens to CZ? Oh, that's a good question. I personally think there is a sealed indictment and they're just waiting to get their hands on him, which is challenging because he won't leave Dubai. Um, I mean, I've read the CFTC and et cetera lawsuit, and I mean, it looks like he did some serious crimes, and I just don't think the DOJ is like, we'll get to it. So I think it's an extradition question, or getting access to him, not a lack of interest by the DOJ. Cool. I think I have made it to the bottom of this, and I am very much losing my voice at this point. So I'm going to sign off. Thank you all for hanging out with me for a couple hours. This was super fun, and I covered way more than I could hope to cover in the newsletter. I mentioned this before. I will be writing a newsletter on today because this was far too long for most people to want to tune into, and I will cover some of the more important stuff in a written form at some later date. Thanks again. You guys are great. Can't wait to keep you updated on tomorrow. Still going to make that decision on whether or not to show up in person, but won't be tweeting about it during the day or anything like that because I will not have access to my phone. But I will keep you all apprised later in the night when I am not several miles above the East Coast. Good night, everyone.